Hello friends, welcome to Litigation Landscape. In this video series, we shall be discussing about concepts and strategies we can use for successful litigation in GST. In this video, we shall discuss about due process. Due process is a word inserted in American Constitution as early as 1791, which says, "No person shall be deprived of life, liberty, or property without due process of law." Article 21 of the Indian Constitution says, "No person shall be deprived of his life or personal liberty except according to procedure established by law." With the judgment in Maneka Gandhi versus Union of India case, procedure established by law has become synonymous with due process as far as jurisprudence is concerned. Due process, in its wider sense, can be summarized as justice cannot be justified unless means are fair, and means cannot be justified unless the end is fair. When we talk about means, we are talking about the due process laid down within a law. In this video, we shall confine our discussion to due process laid down within the law. What is a procedure laid down within a law? Procedure within the law defines citizens' rights and obligations and provides the means to enforce them. It also defines when, where, and how legal action is to be started, conducted, and concluded. It defines when, where, and how legal action is to be started, conducted, and concluded. In GST law, every executive action has a defined process generally laid down by rules. And we must understand that the tax officer is a part of the executive, which is basically concerned with the enforcement of law. And in India, lawmaking power is the exclusive domain of parliament and state legislatures. Then you might ask, what about rules and notifications issued by government? Please understand that section 166 of GST law says that every rule made by the government, every regulation made by the government, and every notification issued by the government under this act shall be laid before each house of parliament and get it approved. So a parliamentary seal of approval is necessary even in the case of rules, notifications, and other regulations. So in essence, we can say that laws, rules, notifications, as well as regulations require parliamentary approval. So naturally, a deviation from due process would amount to litigation by the tax officer. And tax officer is not authorized to deviate from due process, even if the due process is absurd, improper, illogical, or cumbersome. Because Parliament, in its wisdom, has laid down a due process, and the tax officer has no business deviating from that due process, even if the due process invented by the officer is much supreme to what has been laid down by Parliament. So that is the way law stands in India, and tax officer has no other options but to accept this jurisprudence. So we must understand that the tax officer cannot invent a new process. If he does, he will be encroaching into the domain of Parliament, and this is not allowed in a country like India, which has adopted rule of law by its constitution. Rule of law says that a country should be ruled by rules and not by rulers. And India has adopted rule of law by Article 21 of our Constitution. So, any deviation from due process will ultimately lead to lawlessness, and this is not accepted in a society which has accepted rule of law by its constitution. So, what if there is a deviation from due process? First and foremost, we can say that it is a violation of principles of natural justice. In Maneka Gandhi versus Union of India case, the Supreme Court unequivocally held that every procedure within the law should follow principles of natural justice. If you look at it from another angle, you can also say that deviation from due process is a violation of Article 265 of the Constitution. What does Article 265 say? Article 265 says that no tax shall be levied or collected except with the authority of law. So, any deviation from due process shall take away the authority of law, which is called as jurisdiction of the tax officer, and shall vitiate the entire proceedings. Viewed from another angle, you can also say that it is also a violation of Article 21 of the Constitution. It says that no person shall be deprived of his life or personal liberty except according to procedure established by law. So we should be happy that GST law has no provision to deprive us of our life, but almost all GST law provisions in adjudication is designed to take away your liberty. So, naturally, procedure established by law or due process should be followed. So, here also, if there is a violation of due process, it can be a violation of Article 21 of the Constitution also. And please remember, in all these cases, it is possible for you to straight away approach the High Court with a writ petition. You don't have to go to the first appellate authority, then to the tribunal, and then to the High Court. It is possible to approach the High Court with a writ petition straight away. And supposing there is a violation of due process in GST, what should we all do? If there is a violation, we must object to it in no uncertain terms at the first available opportunity. So in GST, notice is the mandatory first step to set the law in motion, and notice must contain all allegations to be adjudicated upon. Without notice, due process has not even commenced. To take an example, Section 73(1) mandates issue of show cause notice. At the same time, Rule 142 says that the officer shall serve a summary in DRC 01 along with the notice. So, a show cause notice is required, and along with that notice, a DRC 01 summary is also required. And what if there is a delay? The law says both these things should be issued together. Assuming show cause notice is issued today and DRC 01 is issued after 3 days, it's a violation of due process. Show cause notice is issued, DRC 01 is not issued, again a violation. So in all these cases, it's a violation of due process. So when the law says that both these things should be issued together, the officer has no business in issuing one today, another thing tomorrow. If you order masala dosha, sambar, chutney, all these should come together to us. The waiter cannot bring masala dosha and say, Sir, the other sambar and chutney are getting ready. You start eating masala dosha. I will bring chutney and sambar when it is ready. It is not possible. So we must get everything together, and a piecemeal distribution is not acceptable as far as this show cause notice and DRC 01 is concerned. Similarly, in all these sections and in all adjudication proceedings, there are very specific mentions as per rules to as to the steps the officer need to undertake, and no deviation is expected or even permitted. But if you look at the real life situations, I can tell you that many people come to me for drafting a letter in reply to a shockers notice. And when I say that we will object to certain procedural errors, some taxpayers would say, no, sir, don't write anything which will antagonize the officer. Then it will have consequences to us at a later stage. So, what is the reason for this timidity? In GST, we have enough number of rights, remedies, and safeguards within the law, and you don't have to be so polite in front of the officer. Actually, you are supposed to stand up for your rights, and if there is a violation, you need to tell the officer that there is a violation. After all, the officer has given a show cause notice telling you that you have done so many violations of the law. Then why are you so afraid to tell the officer that in issuing the notice you have violated a large number of provisions? You don't have to be afraid. And please understand that I am not advocating that you be aggressive or use abusive words with the officer. You need to give them respect, but at the same time, you need to be assertive. Being aggressive is different, being assertive is different. And aggression is not okay in litigation, but assertiveness is a virtue in litigation. And even in our day to day life, assertiveness is very important. So that's the way we need to look at it. We need to be aware of our rights. And if we do not speak up for our rights, we will never get any protection. Because the law never protects a person who sleeps over his rights. So we will be losing our valuable rights if we fail to object at the appropriate time. Let's say what are the consequences if we fail to object to these things at the first available opportunity. The law imposes severe consequences on you if you neglect to object to things which you are supposed to object at the first available opportunity. Basically, the price you pay for this timidity will be the losing of your rights. It will virtually destroy your ability to question deviation from due process at a later stage. And this can be suicidal in appellate proceedings. There are two legal maxims which can operate against you if you fail to object to deviations from due process at the first available opportunity. The first one is there is a concept of acquiescence in jurisprudence which happens when a person knowingly stands by without raising any objection to the infringement of his rights, while someone else unknowingly and without notice acts in a manner inconsistent with his rights. So, if someone infringes your rights, and if you act on that infringement even after knowing that there is an infringement, then at a later stage you will not be able to question this. This is the principle called acquiescence, and this will take away your remedies. And you need to understand that Supreme Court in State Bank of India and another versus M.J. James had held that limitation destroys the remedy but not the right. Acquiescence, on the other hand, virtually destroys the right of the person. So the whole right gets destroyed. But in limitation, only the remedy is destroyed, right remains. So that is the difference between limitation and acquiescence. And the second issue, as far as GST is concerned, is there is a section 160 subsection 2 of the CGST Act, which says that service of notice, order, communication, etc. cannot be called into question if you fail to object it at the first available opportunity. Here also it says that if you don't question these things at the first available opportunity, generally this will be at the show cause notice stage. If you fail to do this, if you fail to question these improprieties, definitely you will lose your right to question these things at a later stage. So you are losing your valuable rights by not questioning this, and these procedural irregularities itself can give you relief in most of the cases if you plead these things at the appellate stage. And now the $1,000,000 question is, what should the taxpayer do if there is a violation of due process? Naturally, the moment you get a notice from the tax department, see what are the allegations which are there in the show cause notice, verify the section, also verify the rule, and see what is the due process laid down by these rules, sections, etc., and verify whether these proceedings are progressing as per the due process laid down in the CGST law. If there is any violation at any stage of the proceedings, it is important that you object to this as the first ground. If there is a violation at the time of issuing a show cause notice, you should use these violations as the first ground itself, that this process has been undertaken without due regard for the due process. Use these as the first grounds. Then if you want, you can give your other things on the basis of merits by stating without prejudice. If the violation is very grave, even that is not required. We routinely give replies stating that this notice itself is non-existent because of this procedural violations. So we are not giving any replies on the basis of merits. Please drop this illegal notice and issue another notice if you want us to participate on the basis of merits. We routinely give this kind of replies also, and we do get successful results in appeals also in such cases. So that is something you need to consider. So we need to understand a judicially settled concept as far as due process is concerned. This concept is called Taylor's principle, which was laid down in a famous case, Taylor versus Taylor in 1875. This principle says that if the manner of doing a particular act is prescribed under any statute, the act must be done in that manner or not at all. If the manner of doing a particular act is prescribed under any statute, the act must be done in that manner or not at all. So basically, this principle says that follow the due process or don't undertake any proceedings. And this has been relied on for the first time by the Privy Council in a case called Nazir Ahmad versus King Emperor. And this has been used by various courts, including the Supreme Court, in various judgments. So, this is a very fundamental principle in the law. If something is required to be done in a particular way, it has to be done in that way only or not at all. So, we can use this principle if there is a deviation from the due process. Thank you so much for watching. See you with another video in litigation landscape.